All right, good morning. We're going to go ahead and get started since we have a good bit to run through today. Thank you, everyone who's joining us today. We're discussing e-commerce law. So what to know about branding, copyrights, trademarks, and privacy in launching or optimizing your digital business platform, whether it's for products or services. I'm presenting today along with Lauren Hughes. We're both from Rockridge Venture Law. And I won't bore you with stereotypical lawyer talk about our backgrounds and interests. We have this slide in case you want to contact us or look further into what areas we practice. Rockridge Venture Law is an intellectual property and technology firm. We have offices in North Carolina and Tennessee, and we are a B Corp Best for the World. That means that we operate according to a triple bottom line business model, where we take into account environmental and social impact along with profits as measures for our success. Some of our practice areas include intellectual property, litigation, acquisitions, technology transactions, and financings. We are not your lawyers. Here's the ubiquitous legal disclaimer. Of course, we'd like to be if we can help you out with anything, but as of right now, we don't represent you. So it's important to say that anything in this webinar is not guaranteed. In fact, it can actually harm, maim, or otherwise defeat you, say for instance, if you're watching it on a scooter, or if you are working from home and you have kids playing in the oven behind you. So just consider that everything that we say here is not direct legal advice to you. So why are we here today? It's important to recognize that 2020 is a lot different from 2019. And for branding purposes, we have this crazy combination of social distancing, teleworking, companies trying to save overhead, and now we are an e-commerce everything marketplace. As you may be reading, the retail environment is quickly changing. Amazon's hiring hundreds of thousands of employees to meet demand since we're all shopping on Amazon while we're working from home. The retail industry is changing. Companies have to figure out how to approach direct-to-consumer business models that they might have, how to transition out of brick and mortar online and doing that quickly, and then maybe permanently doing that if retail trends stay the way that they are shifting. Lots of significant impacts on the retail industry right now. These articles are linked on our last slides in case you want to go back and look those up. Thinking about the intellectual property environment we're in, we're also in an age where we see significant copyright and trademark trolling activity. And we'll explain that a little bit later, but basically you have large companies, in some cases, who are going and playing whack-a-mole on small businesses everywhere and threatening and sometimes actually opposing trademark applications, sending threatening letters, filing harassment suits based around their intellectual property portfolios. In some cases, you have some businesses and individuals who are harassing people through different complaint filings, say with YouTube, with Google, with Amazon. They don't actually even hold rights. They're just trying to take advantage of what's kind of a broken system right now. When you're thinking about e-commerce, there is an IP in e-commerce. I like to say that the IP is silent. And when you are identifying that IP, then you have to think through questions like, what's the difference between a copyright and a trademark? What is copyrightable or infringing about my brand? What might be trademarkable or infringing about my brand or product launch? What are actual benefits to copyright and trademark protection? I mean, really, are there? What's the difference between a strong and a weak trademark? What is the difference between a federal mark and a state mark? How does Amazon's brand registry program work? Is there any federal policing activity that I can take advantage of, like with customs for overseas counterfeiting? And then how do I keep competitors on Google, Amazon, Etsy, all these different platforms from trading on my name, exploiting rights? There's also a legal embedded in e-commerce. And that's more about what I need to know about customer privacy protection laws and consumer protection laws. These are laws at the state levels that protect shoppers of your products or consumers of information on your different websites, social media platforms, and various touch points. So we'll kind of start by walking through trademark a little bit. That's one that may be at the forefront of any business owner or manager's mind, or of a creative team that's building a campaign or an asset platform for a customer. That's usually the thing we think about because it's so prominent on a lot of the labels we see the little circle R. So we'll talk a little bit about trademark, and then we'll go from there and talk a little bit about the differences between trademark and copyright, what the benefits are of those, and then talk a little bit about some of those other consumer protection laws. In terms of a trademark, there are lots of questions that you want to think of on the front end of preparing any sort of trademark strategy. And so typically what we deal with in our early conversations with clients are, what's the difference between a registered and an unregistered trademark? What makes a good trademark? What's the difference between a federal and a state trademark? Didn't know that there was such thing as a state trademark. It's something we often hear. How do I actually get one? How long does this take? How much does it cost? What's the process? And what are the true benefits of obtaining trademark registration, as opposed to just kind of going out there and having a great name and great brand and slick look and doing it that way instead of messing with all these registrations? Well, the fundamental aspect of a trademark is it is a source identifier and distinguisher. Right now, all of us are feeling the pains of this global adversary, this coronavirus, COVID-19. And so what we're seeing a lot are rallying cries from cities and states. Maybe you see in your city, XYZ strong, or XYZ resilient, or XYZ community stands. And you're seeing that hashtag on Facebook and Instagram posts. A lot of people are using it. Maybe they're using it for fundraisers. That's not a source identifier. That's a common rallying cry. It's a phrase that people can motivate around, and that is not a source identifier. A source identifier is some sort of mark that can lead a consumer and point them back to a particular company, even if they don't know the legal entity that is that company. They can recognize and distinguish a particular mark from others and know that it is a source identifier for a particular company. That is the first and foremost aspect of a trademark. What are some things that you can trademark? Well, for the designers who are on this call, there are lots of possibilities here. You can trademark a business name, a product name, slogan. You can trademark a smell, color, logo, shape, number, anything that can be a source identifier. Before this call, Lauren mentioned to me Chanel number 5. Okay, I'm not a Chanel number 5 guy, but in thinking about that, I mean, you've got a number, you've got a bottle shape, you've got a brand, you've got a scent. There's so many different things about that you can protect. And lots of different marks, lots of different things that your customers and potential customers can touch and feel, things that are visceral, can be protected and exclusively protected by you. Here's some examples of our trademarks, some but not all. And this is just to show you some different aspects. So you could trademark your business's name, maybe an abbreviation or a shorthand for that name, maybe a phrase or a slogan that you like to associate with your business. All these things can be trademarked. What we have here on the slide are 3 word trademarks. So the trademark office differentiates between word trademarks and design trademarks. So word trademarks are what you see. They're spelled out letters. They are combinations that if you incorporate them into different designs, that word, that phrasing is still protected. Generally, we like to say that those are stronger trademarks than design trademarks. And a design would be, for instance, our logo in the bottom left-hand corner of this slide. That's a logo that if we had protection in that logo and we changed that logo, we spiced things up after a couple of years, then the literal elements in that logo might be lost. We might waive those by changing our design. And that's because when you submit a trademark application, the examiner looks at all of the different pictorial and graphical elements of your design mark in comparison to other similar marks to decide, is this a distinct and unique mark, or do I need to reject this mark? And so that's important to know that you have some difference between a word mark, which is a broader, stronger mark, than a design mark, which has a lot more nuance to it. And these are good parallel strategies to have both word marks and design marks. I just want to point out the difference there. We get a lot of questions about font. Font is not design. So if you have a word mark logo that has a really unique font to it, that is not considered by the trademark office to be a design mark. That font is the same as any other font to the trademark office. They're going to look at that as a word mark. So you've got to include some sort of graphical element to that if you want it to be a design mark. Who trademarks? Well, lots of companies, lots of individuals trademark. I threw up just a quick search of trademark filings by some maybe well-known, maybe lesser-known entities. And the purpose of this slide is to just kind of show you how trademark filers run the gamut of filing according to lots of different things. How pervasive they are in terms of their products, what their customer base is, and all the way from a brewery, Rogue Ales, located in the Northwest. Not everybody drinks beers, not everybody drinks microbrews. They are a national name, but maybe they don't have to file thousands of trademark applications. Taylor Swift, yeah, a much bigger name, international star. But not everybody listens to music. Not everybody listens to Taylor Swift. And there are also some other complications around trademarking different aspects of personality. And you run down the line here to some very large companies that service everyone. A Bank of America, everybody banks. And they're actually in a pretty traditional and stale industry. There's not a lot of excitement to banking. And so that's why you see lots of different seasonal campaigns and different ways to appeal to consumers, and lots of refreshing to try and get customers in a pretty stale industry. So that's why you might see so many trademark filings by a company like Bank of America or IBM. It's important to note here that again, this is just a quick search. There could be licensee trademarks. There could be lots of other marks that we are not seeing. These are just quick search filings. You also might see a lot of generic terms in the trademark filing database. And this is not a very good thing. And on the next slide, I'll talk about this a little bit. But you want to think creatively about whatever you're calling your campaign or your brand. To see that there are 21,000 trademark filings using the word best, that's not a good thing. If you're trying to convince a trademark examiner that your brand is unique, using a word like best is not going to really get you there. So just in terms of thinking creatively, you want to avoid these kinds of words and very generic descriptive terms or quality type terms. In most cases, you're gonna have to disclaim them anyway. They're not going to become a part of your mark. So if you are trying to convey some information like this, then it's important to think about a different way to do that. So what really makes a good trademark? We get this question a lot. And so we developed this little infograph that we think is a really nice little shorthand, easy way to look at it. It's obviously not comprehensive, but the way I like to look at it is a MAD mark is worse than a RAD mark. SAD mark is somewhere in the middle. A MAD mark, you're really probably not going to get trademark protection around, either registered or common law trademark protection. It's a merely accurate and descriptive mark. There's absolutely nothing creative about the mark, and it simply tells what a business offers in terms of products or services. So, Paul's ice cream shop. All right. So if Paul sells ice cream at this ice cream shop, he's probably not going to be able to trademark that. Even if he had a really fancy logo, it's still going to be tough to trademark. Whereas a SAD mark, you may get a little bit more traction there if it's, say, Paul's plumbing, or Paul's piping works. You've got some alliteration there, so you've got a little bit of creativity in the word. You're not generally saying exactly what you sell. You maybe offer a host of different kinds of services. That might move you closer to a SAD mark that's suggestive of what you sell or services you offer. It's alluding to directional. This is where most of the trademarks fall, because it's a nice balance of having some creativity, but then also consumer recognition of what is it exactly that you're offering. RAD marks are going to be the strongest marks. A RAD mark would be a Google and Amazon. The word Amazon, which most people before the company Amazon associated with the South American river, is now an online marketplace. And so we all understand that now. And if you see at your local retail store any Amazon product, an Amazon toaster or a Google espresso machine, you're going to immediately associate that with those companies who are behind it, because it's such a random, arbitrary, and distinct, disconnected word mark or logo around what it is they offer. So nobody's going to be able to get close to them in terms of what they can use to identify themselves or their products. And that's why it's so strong. So you can kind of see the interplay here a little bit, and we have an article that's linked there and on our site that you can go and explore that a little bit more. But when we're working with clients or design teams who are assisting clients, we try to push them somewhere in that medium of SAD and RAD, give them that anchorage where the product can be evident to consumers, kind of what it is. But also strong enough to be very, very unique and very, very enforceable against others. So how do you get a federal trademark? Well, here's sort of a breakdown of the timeline and the different gates that go into actually getting a federally registered mark. So you should start out with a search, and that's a search for, hey, I have this idea in mind. I'm going to search to see in the databases, the state trademark databases, federal trademark databases, the international trademark databases, to see are there any very, very similar or the same marks out there. And then also maybe going a step further, looking at consumer product markets and marketplaces to see, do I have freedom to operate? There's actually a difference between is something registrable as a trademark, and do I have actual freedom to operate to use this thing? Is somebody going to come after me and shut me down? And this happens. I mean, we see clients who they spent a lot of money to launching a brand or a product, and they didn't do any due diligence on the front end, and then they're looking at $100,000 rebrand a couple months down the road because they're directly treading on somebody else's rights. So it's a good, important step to do some sort of search. How involved that might be is kind of up to you. The first gate then would be the examiner. So a trademark examiner is going to look at your application, determine whether you've met all the procedural requirements to obtain a trademark. Then they're going to look at the substantive requirements to determine, is your mark, is your application similar to anybody else out there? And if so, then I'm probably going to issue an office action. I'm going to say, hey, you got to convince me through argument that this is different and unique, and is not infringing upon these other marks that are in my database. If the examiner clears you, there's no office action. You go straight on to publication. It's sort of a technical term. It's not really that your application is not public until that point. As soon as you file your application, you can find it online. But that's sort of a technical term, historical term, to a period of time where third parties can then come and challenge your mark. And so there's a 30-day window for some third-party company to come in and say, hey, I have standing. I can come in. I have the power to come in and challenge this mark because there's some way that this mark that's going to hurt my business. It's going to do something to obstruct my business, and so I have a pretty clear interest here in opposing this mark. If that happens, then it kind of turns into an administrative dance, sort of like a quasi-litigation between the two entities to determine whether the application, that mark that is applied for, is free and clear and distinguishable enough from the third party's mark. That doesn't happen, then after your 30-day window, you'll receive a notice of allowance, and at some point in the next couple months, you'll receive your issued mark. So usually it's an 8-9 month process to get your federally registered mark. But as soon as you apply, you can use the little TM beside your mark, and we always encourage you to do that for various reasons. And then as soon as your mark is registered, you can start to use that circle R. And lots of benefits to trademark registration. You can use it to bump competitors off of different platforms, like your consumer marketplace platforms, your Amazon, your Etsy. People who are using your name, maybe you're the #1 brand in the market, they're using your name in their Google ads or as keywords in their Google ads. So you may have some power there to assert your mark in complaints in the process that Google has. You can bump squatters off of domains that you really want once you have a registered trademark. And you can file your trademark with the U.S. Customs to take advantage of their policing services against counterfeiting goods. And we've been involved in one of these cases, and it really works. This case involved a manufacturing center in China that was producing goods for a trademark holder and selling the same goods right out the back door on Alibaba. And so Customs was able to capture thousands and thousands of products that were coming in via that route because of this border protection program. So it's a good thing to pursue, and it's a great benefit to your registered trademark. And then just going directly after your enemies. Once you have that circle R, that federal registration, you can send a much nastier nastygram to them to back them off of your mark. You can bring a lawsuit with willful infringement. You can get triple damage awards in court. There's a presumption of ownership and validity to your mark, can be, and of your exclusive right to use that mark. So there are lots of very, very valuable aspects to trademark, and we're increasingly seeing banks and other lenders who are collateralizing intellectual property. So you do have a valuable asset, just like your physical assets in your business. You have an intellectual property asset once you have these types of registrations. So it's important to know if you're going out and leveraging your assets for loans or scaling up and trying to get investment money, then that's an important piece to the puzzle. Some other things to know is with federal trademarks, you can actually kind of shotgun marks. So if you have an idea in mind, a phrase in mind, well, you're not yet using it, and you probably won't be using it for 6-7 months. You're working with a design team. They're going to build your site and your campaigns and everything, but it's going to take a little while. You can go ahead and file the application to sort of lock down that mark, and then your application will proceed through normal examination, and really you have up to about 3.5 years to show that you're actually using that mark in commerce in order to get your registration. So it's a nice little aspect of sort of calling shotgun on how to actually get your mark. So in terms of difference between a federal and a state trademark, there are state trademark laws that are independent and unique from the federal laws. This is sort of different from other federal intellectual property laws like patent law and copyright law. A state trademark affords you only intrastate protection. You can only use it against others within your state where it's registered. You don't get that fancy Circle R. Sometimes it's challenging. State courts are usually less knowledgeable about intellectual property, and they don't have law clerks running around and tons of resources to learn about intellectual property. There's also usually not a lot of case law for your attorneys to work with around state trademarks. You have to, in most cases, in order to get a state trademark, show that you're already using a particular mark before you can get it. But the great thing about it is cheap and easy. Whereas a federal trademark might take many, many months or years to obtain. We see state trademarks issued in just a few days. And it's usually a one-page form that goes into it. Many of our clients can do it on their own. So it's a really nice thing to do if you are submitting a federal application. Then you can go ahead and get your state trademarks. You're protected on the ground in your state while your federal application is moving through the process. Just to kind of reiterate that rad, sad, mad infograph, whimsical marks are better than suggestive. You have to be careful of geographical, informational, or personal marks. These are usually considered by the trademark office as merely descriptive. They don't offer any sort of source identification or creativity or uniqueness. So you have to be careful categorically with those types of marks. Design elements are differentiators. So if you're using a word, like if you just feel like you have to use ninja, then you might want to incorporate ninja into a unique design, and that will help secure trademark registration. If there are lots of other ninja marks out there, you can use that design to argue against examiners' rejection or potential rejection for similarity with other marks out there. Trademarks are class specific. This is also something important to know. So you may have some other filing out there that has a name or a similar name to yours, but trademarks are class specific, and what that means is under international treaty, about 41 different classes of trademarks, and so these trademark offices around the world, they try and group different products and services together in similar categories. And so if you have a dishwasher type of product that you're trying to protect, and there's a trademark holder that has a trademark on microwaves, you're probably not going to be able to register your mark in light of the microwave trademark. However, if you're trying to register a trademark for a dishwasher, and somebody else has that same name or similar name, but they're using it for software, and that's where their registration is, you stand a much better chance of getting your similar or same mark registered because it's distinguishable enough. There are different consumer markets around dishwashers and software, although IoT not so much in the near future. But historically, that gives you a good chance to say, hey, it's distinct enough, and I should be able to get a trademark as well. Trademark infringement usually happens in three categories. Likelihood of confusion to source. Is Mountain Dew, is that made by PepsiCo? I don't know. Likelihood of confusion as to relationship. Well, Mountain Dew, I guess PepsiCo signed off on that. If they're letting somebody rip off Mountain Dew like that, there must be some sort of license or permission there, or dilution. And I heard Mountain Dew randomly explodes in refrigerators, so I'm not buying anything that has Mountain on it ever again. Okay, that is diluting Mountain Dew and PepsiCo's mark that they've invested so much money into, and you have some random untested product that's going to come and sort of taint their image. That's dilution. Those are the three main areas where we see trademark infringement claims or trademark infringement suits. I'm going to turn it over to Lauren and take a little breath here and allow her to talk some about Amazon's brand protection program and some differences between copyright and trademark that's important for you as business owners or for you as designers working with businesses.
Thank you, Kevin. I'd like to dive into one of the ways that trademark holders can protect their brand, and that's through registering your marks with Amazon's brand registry. Now, the major benefit of signing up with this program is that it does a lot of the heavy lifting, self-policing mark owners should be conducting for all of their marks, whether that's for your business name, your product names, or your logos. Amazon's AI, that is its artificial intelligence, crawls through all the listings on its platform, pinpointing content that might be inaccurate or infringing. The more information that you can give this brand registry about your trademarks, the better the platform can locate infringing uses. For example, the brand registry can locate products listing use of your trademarks in their titles, but they're not actually associated with your brand. Or product images that feature your logo, but are products that you sell, or at least that you don't sell under that particular logo. Sellers that are shipping products from countries that you have no connection with, either as a manufacturer or distributor of your brand, and other product listings that have been created under your brand name when you've already listed your full product catalog on Amazon's platform. Next slide, please. So if you're already selling on Amazon or intend to, it's a good idea for you to enroll your current trademarks under Amazon's brand registry program. Only certain trademarks can be enrolled in this program, and that's the most common ones, those that are literary or design, such as words or logos. Sounds, colors, smells, and other source identifiers that Kevin mentioned are trademarks, but they're unlikely to be products offered on Amazon's platform under those indicators, so you cannot register those sorts of trademarks. You can only enroll registered trademarks unless it's a pending trademark that's going through Amazon's IP accelerator, which is the company's fast track to protecting your marks. Once you've obtained a registered trademark, you'll need to ensure your marks are actually on your products, your packaging, or your labels. Typically, mark owners are already completing this step, but you might have to change things up a bit if you're selling unmarked products on your own website, whether the marks had only been attached to that site themselves and not the products. When you enroll in the brand registry, use your vendor or seller central credentials to sign in, which can give you additional benefits that are offered under those vendor seller programs. And not just anyone can enroll a brand under the brand registry. The first enrollment has to be by the owner itself, and then that owner can then go in and have its seller agents enroll for the brand too. One thing you should keep in mind when using Amazon's platform is to know that it's undergoing some pretty significant changes at the moment. Sellers often put a lot of time into learning Amazon's algorithms to become the first in their class, but with Amazon currently hiring a lot of workers, the algorithms are changing, meaning that that platform is going to be a little unsettled for the near future. I believe that Kevin thoroughly covered the more nuanced elements of trademark law. So Kevin, if you don't have anything else to add, I'll jump into copyrights. And next slide, please. First, before going into too much detail, I'd like to cover this little chart that I made that showcases some of the more significant differences between copyrights and trademarks, since they're often confused, and for good reason, because logos can fall into both categories. First of all, copyright and trademark law offer different scopes of protection. Copyrights cover creative or intelligent works, while, as Kevin said earlier, trademarks are source identifiers. These two intellectual property assets are governed by two different offices. copyrights being controlled by the U.S. Copyright Office, and trademarks, along with patents, being managed by the U.S. Patent and Trademark Office and additional state laws. There's no such thing as a state copyright, while state trademarks are almost always quicker and easier to obtain than your federally registered counterparts, and cheaper too. The life expectancy for copyrights is significantly shorter, as trademarks, so long as they're used and maintained, can live forever. While a copyright filed by an individual can only survive for the life of that individual, plus 70 years thereafter, or if filed for a business, 120 years from the date of creation. There are some exceptions, but I don't want to travel too far into the weeds. If you need more information on the life expectancy of your own particular copyright, you can give me a call and I'd love to be your lawyer. When filing for a registered word, work, or mark, a copyright must first exist in tangible form. That means that it needs to be written out, typed to paper, or saved to your computer. A trademark, on the other hand, can be filed under the current use or intent to use doctrine, meaning that you don't actually have to be selling products or services under that mark, you just intend to. You will, however, need a drawing of your conceptualized mark if it's a logo. Lastly, and a very significant difference, is that copyright law allows copyright holders to receive statutory damages, minimum statutory damages, which is why you'll see a lot more effort behind copyright infringement actions than trademark actions. There's almost certainly a guaranteed payday. Statutory damages for infringements that cannot be clearly proven either as innocent or willful are usually between $750 and $30,000 per work, as determined by that court. The exact amount is going to depend on the seriousness of that infringing act and the financial worth of the infringer. On the other hand, an innocent infringer, that is someone who didn't know that they were violating copyright law, may have to pay as little as $200 per work. This would be especially true if that work didn't have a proper copyright notice, which we'll cover a little later in this presentation. An intentional or willful infringer may have to pay as much as $150,000 for a single infringement of one work. Statutory damages are going to be awarded per work, meaning that if an entity used 7 or 8 of your designs, that entity is now liable for statutory damages for each one, for a total of 7 or 8 awards. When a typical award ranges between $750,000 to $30,000 per work for non-innocent or non-willful infringement, you're usually looking at an award between $5,000 to $210,000 for taking a measly 7 images to use on blog posts. As you can probably tell, this minimum statutory damages framework is very important because its alternative is to award actual damages, which are the damages that must be proven in court and can be very difficult to determine because you have to calculate the profit that would have been made from some imaginary license that never occurred, as well as any additional profit that infringer received as a result of using your works without permission. Next slide, please. For this reason, we're also seeing a rise in copyright trolls because they believe they can easily access these minimum statutory damage awards. A few of the instances that we've seen in the IP world are when these huge publishing houses holding millions of copyrights in music will send informants to bars and other venues hosting live music events. While the bars and music halls might only play music they've licensed over the speakers, if they host a karaoke event or open mic, these informants will sit down and list every song played, send it to that publishing house, which will then go through that list to ensure that every single song performed was licensed. If even 3 or 4 of those songs were not licensed, that hometown bar could be liable for thousands in copyright infringement claims. One recent call we had was an injury suffered by a local business when another larger company utilized artificial intelligence to crawl the web for uses of unlicensed or unattributed photos. While these companies might be engaged in legitimate efforts to protect their works, sometimes we'll see companies that only purchase the copyright after it's found an infringing use. Other times, these companies will send big, scary letters to these small business owners and not even hold a registered copyright in the works at all the same demanding payment or threatening a lawsuit. One last use I wanted to mention is this pretty interesting case where a gaming company had a sports-themed video game. It had obtained all the right permissions and uses to use the professional athletes' numbers and their likeness, but one thing that they forgot was to dive into the details. In creating this game, the gaming company wanted to be as realistic as possible, so it even mimicked the tattoos of the players that were in the game. While the company had permission from the players to use the likeness, it did not have permission from the tattoo artist to recreate the tattoo. And we'll discuss ownership here in a minute, but an opportunistic third-party company then went in, purchased the rights to that tattoo image from the tattoo artist after the game had already been released. They were then able to sue that gaming company for some big bucks because at that time, that gaming company had sold millions of copies of its game, meaning that there were a lot of instances of infringing use. Under trademark law, in comparison, courts are going to have a wide range of discretion in setting any statutory damages for trademark infringement. They might award anywhere from $500 to $100,000 or anywhere in between per counterfeit mark for each type of good or services offered under that mark. With willful infringement, you could expect anywhere up to $1 million, but there's no statutory minimum. Next slide, please. There's a large range of works that may be copyrighted. Most of the popular categories are listed below, which I'll cover. First, we have literary works, which are going to protect not only books and poetry, but also your blogs, articles, and other printed texts in your marketing materials. With performing arts, as might be relevant to your business, that class is going to cover any sound recordings or podcasts that you put out. Your visual arts are going to cover the visual and photography elements of any ads that you might have, as well as your logos, which can also be trademarked, your website, your labels, and your product packaging. Digital arts cover your GUI, that is your graphical user interface, your apps, and even virtual reality environments. Motion pictures include commercials, banner advertisements, and slide presentations, while photographs are going to cover everything up to and including selfies. Next slide, please. Some of the benefits you'll receive with your copyright registration is not just going to be peace of mind, but also access to a few of the things we've already talked about, such as filing complaints with online platforms like Google and Etsy, and access to minimum statutory damages. Like trademarks, you can file your copyright with U.S. Customs to prevent international infringing uses from coming into the country. And you'll also have the presumption that the work is a valid copyright, you're the owner, and that everyone in the nation has constructive notice of that. You'll receive parallel protections in other countries that are part of an international treaty based on that U.S. registration, and you'll be able to sue in federal court to make it easier for an infringement claim against any out-of-state parties. Next slide, please. As promised, I'm going to quickly cover how to give proper notice of your copyright to the world so that your minimum statutory damages will start at $750 rather than $200. Next to the work, you'll need to put the copyright symbol known as C, the word copyright or its abbreviation, and the year of first publication and the name of the owner. For example, at the bottom of the Rockridge website, which the firm has claimed as its copyrighted work, you'll see C 2020 Rockridge Venture Law. Next slide, please. Lastly, I'd like to mention what it means to be an owner of a copyright and who is that owner exactly. This might address some questions you had about why a professional athlete was not considered the owner of a tattoo that he had inked onto his own body and that he had paid for. As a general rule, the individual that creates the work owns the copyright. There are some exceptions, such as if an employee creates the work as part of his employment, then that employer owns the copyright, or if an independent contractor creates the work as a work made for hire, or if the creator of the work sells the entire copyright to someone else. Typically, we'll see a lot of media and design contracts that do not assign the rights to the copyright, they don't sell the copyright to the purchaser. The contracts will only give that buyer a license, that is permission to use the designs or media, but not to own it. In the case of the tattoo, the professional athlete paid for the tattoo to be done and have it on his body, but he did not purchase the tattoo image, meaning that that tattoo artist could recreate that design on someone else or sell it to a gaming company for big bucks. If the athlete wanted to have exclusive rights to that design, he could have purchased the copyright, which would have been more costly than just simply purchasing the tattoo, because when you purchase a copyright, you're purchasing the right to control its use. Kevin, I think that just about sums up an intro into copyright law. Do you have anything else to add?
Yeah, and I'll just follow up on that point. As we're talking generally and thematically today about e-commerce transitions or e-commerce investments, this is an important point. We really see a lot of inadequate agreements between businesses who are securing design services from third parties, from design houses, and general misunderstanding as to what permissions the business needs, what rights the design house retains. The design house might want to recycle a lot of the content, a lot of the designs for other parties, or use them to basically say, hey, look, we created all these fancy designs for these businesses, or even to just sort of hold back certain rights to say, well, you know, we'll give some limited rights to this design, but if this really blows up, if this business is featured in a movie one day, then we're going to retain those rights so that the movie house needs to come purchase those rights from us instead of from the business. For the business owner's perspective, you need to really understand what rights do you need, and you may want total control and total ownership so that you can do whatever you want to with it. And it's not going to become an issue if you expand into different platforms or once you start to do due diligence in an acquisition. And so really it's just something I wanted to highlight, that there's really not enough detail in most cases we see between designers and customers around creative works that have copyright value and intellectual property importance. And we're kind of coming up here on an hour, and I want to have some time for questions. So I'm not going to get into some of the other things that I wanted to talk about today that are really around privacy and customer controls. And so just briefly, after some of the big data breaches and malicious use of data over the last few years, we first started seeing heightened data control laws in Europe. And that has now been taken up by several states in the US, or at least important states where there are a lot of consumer markets like California. And so you need to have the proper disclosures and user controls over how you're using data through your different campaigns. And that could be just your website, email campaigns, social media campaigns. These need to be legally compliant. If you are operating in the US today and you have some sort of online business, then you are pretty much going to be subject to the California laws, because it's inevitable that you're going to have a California customer. So it's important to kind of understand what some of those rules are, and to be creating your products and your brands and your campaigns in compliance with those laws. And then there are also state-by-state consumer protection laws to make sure that you are not promising something in your ads that may be misleading, or saying things that are confusing customers. And these state statutes are pretty strong. They often have treble damages attached to them, to where if you can show that you were consumer misled by some advertisements or some businesses, that you can obtain pretty significant punitive awards. And then also state by state, you usually have laws around use of likeness. So that's another component, is that personality aspect, where you may have some limitations on what you can do in building your campaign, featuring certain people or likenesses or references to people. And so it's a lot more than intellectual property that you need to think about if you're ramping up some of your e-commerce platforms. These are all important things to consider too. So I just want to kind of leave it there. I've got a couple of resource slides that we reference in terms of the articles, and these are made available to everyone who participates live or on demand. Then I'll leave our bios here as well, in case you want to jot down our contact email addresses. Please feel free, if you're on the line, to submit any questions. We're going to hang out for several more minutes and field any questions. I believe that Lauren was going to answer a question here that she has marked. But if you've sat through this long, then please answer any questions. We'll be happy to address those for you.
All right, so jumping into questions here, I'm actually going to break this one long question into two. So it was asked, if the prior art search or freedom to operate analysis both looks good, what are the chances of success for allowance? So I'm going to give a very legal answer and say it depends. We have a lot of small business clients who are a little wary about spending a lot of money on the front end to conduct any sort of clearance search. So they'll take that matter into their own hands and do their own clearance search. And where we'll see a problem is that they don't know exactly how to conduct that search properly, because their knowledge of trademark law is a little limited. So they might do an exact word search. So if they're wanting to trademark Rockridge venture law, they might just search for Rockridge venture law. But trademark law is the law of confusion. So you're going to want to see, you're going to want to search for one letter off, so Rockridge's venture law, or change the words up, maybe Blackridge venture law, and kind of extend your search in that way. So we do offer a couple of different comprehensive searches where we'll search the trademark database itself. We'll use a few different other resources available to us to conduct a common law search. So that's a search for unregistered marks. That can be a little harder to find, but can still cause problems down the road. So if someone who's knowledgeable about trademark law and conducting searches is conducting your search and spends extensive efforts into doing a very, very thorough search, then your chances for success are very, very high for that. And Kevin, I will leave this second question to you. Actually having computer issues, I can't bring it up.
Yeah, so the next question is really about international trademark protection. And so the good thing here is that you have an international treaty. And so copyright, patent, and trademark protections extend internationally by treaty. And most of the target markets for trademark purposes are going to be covered under these treaties. And so you can start a trademark application in the US, obtain trademark protection here, and get some priority coverage for going international after a certain amount of time. So you could basically expand your trademark coverage beginning in the US, internationally, and go through kind of a central system where each state is going to have its own fees and slightly different processes, but there's a lot of similarity, which is really, really nice. So I would say that there's not really a lot of difficulty in transitioning from a US trademark strategy to an international trademark strategy. There are more moving parts, of course, because just as in the US, you have many companies who only have trademark registration in the US, they've never gone internationally. In all those other countries abroad, you have the same situation where companies have only secured rights in their particular countries. So maybe it was really, really easy for you to get a trademark in the US. That doesn't necessarily mean you're going to get it in Europe or Australia or some other place, because there may already be companies who have registered or protected rights in those countries. So it really starts with a good search strategy and planning strategy for moving from the US internationally, and just being aware of the uptick in different costs, which includes maintenance costs as well. It's not just the application fee, but ongoing maintenance fees around your applications or your registrations.
And we had a second part question here that I'll pose to you, Kevin. Is trademark prosecution and regulation less convoluted than patent prosecution and regulation?
Very, very much so. You know, patent guys are just nerds. Patent guys and gals, excuse me. And so, as you might imagine, all the patent rules and even the nomenclature is really nerdy. So, for instance, for patent applications, you have what's called a patent provisional application, and then the follow-up to that is called a non-provisional application. So it's really uncreative, and so all the processes are very technical compared to trademark. Trademark, it's much cleaner. Even the websites are just so much more user-friendly, and so in terms of prosecution, and that word really refers to sort of the negotiation, the back and forth between an applicant and an examiner. It's not prosecution like going after criminals. It's prosecution as, I have an applicant, I'm trying to convince you, examiner, to award me registration on this application. The back and forth is much simpler. There aren't a lot of fees associated with it like you have in patent. And it's much nicer. So they're part of the same office as the U.S. Patent and Trademark Office, but they're completely different cultures. And I would love to see the Patent Office move a little bit towards trademark culture. So we don't have any open questions now, and we're coming up on an hour. So we'll just we'll wrap it up now. This webinar will be on demand, so anybody who appreciated it or felt like there was useful information, you can go back and visit anytime. And then you can also you'll find it on our website, and you can use it to share with potential clients or associates. And we hope that this helps you. And we're available for any ways that we can help you after this. So thank you very much. Stay healthy and enjoy your afternoon.
Thank you, everyone.